Welcome to Law Talk NH Unfiltered. Today we're launching a new series called Granite State Crimes, where I'll dive into some of New Hampshire's most significant and challenging criminal cases, and we'll explore the law behind them. Before we begin, I want to acknowledge that this episode covers a recent and deeply tragic homicide case involving the death of Marisol Fuentes in Berlin, New Hampshire. My heart goes out to her family, friends, and the entire community during this incredibly difficult time. This episode is intended for educational and informational purposes only and is not meant to cast judgment or interfere with any ongoing legal proceedings. I approach this discussion with respect and sensitivity to those affected. Now, today we'll be exploring the legal issues surrounding bail decisions, the role and oversight of magistrates in New Hampshire, and how magistrates can be reviewed and or removed. This includes a fairly detailed look at the case of Michael Gleason Jr., the charges he faced, the bail decision that allowed his release, and the public and legal questions that followed. Now, let's dive in with the facts. So, police were called to La Casita restaurant in Berlin around 9:45 a.m. today. That's July 6, 2025, for a report of gunshots, according to the New Hampshire Attorney General's office. When they arrived, they found an employee identified as 25-year-old Sandra Marisol Fuentes, dead behind the bar from apparent gunshot wounds. Later on, investigators found 50-year-old Michael Gleason Jr. in a bathroom, dead of an apparent self-inflicted gunshot wound. Now, Michael Gleason Jr. was Fuentes' estranged husband. He was released on just $5,000 bail before he shot her. He was also ordered to have no contact with Fuentes and to possess no firearms. A court document showed that Gleason was facing felony kidnapping and sexual assault charges stemming from an incident involving Fuentes back in April of 2025. Now, this tragedy has stirred up a lot of, justifiably so, anger and anguish. For example, State Rep Lori Korzen, a Republican who represents Berlin, said in a letter to the magistrate that issued the bail order, and that's Magistrate Stephanie Johnson, that the decision to set the bail so low, despite what he was charged with, had a devastating consequence for Marisol and her family. And this has been a big issue. I believe an executive counselor has spoken out against this, and there's a sense in the community that the system failed somehow here. The system obviously failed Fuentes in some sort of sense. The question is, how so? And what can people in New Hampshire and the representatives do about it? Okay, and how we can identify it and change the laws if we need to do that. There's been a lot of calls for Magistrate Stephanie Johnson to resign, but we'll talk about more how a removal of a magistrate would take place rather than discussing any opinions. We'll just stick to the laws and the rules in regard to what occurred. Okay. So first, now that we've talked about the facts in a very general sense, there's been a lot of outrage about magistrates. So first, we need to identify what is a magistrate. Okay. Now, magistrates in New Hampshire are appointed by the Chief Justice of the New Hampshire Supreme Court, and that's in consultation with the Chief Justice of the Superior Court. So think of that person as the head of the Superior Court, and also in consultation with the Administrative Judge of the Circuit Court. So think of the Administrative Judge of the Circuit Court as the head of the New Hampshire Circuit Court. That's your lower courts, the district court, where most people that go to court will usually find themselves. And think of Superior Court as, that's where felonies will eventually be addressed. Those, Superior Court is for major crimes where people have jury trials for major lawsuits, stuff like that. So RSA 491-B:1, this authorizes the Chief Justice of the New Hampshire Supreme Court to appoint at least 3 magistrates. So the law says Chief Justice of the New Hampshire Supreme Court, you get to pick 3 magistrates at least. So that means there is room for more, but the room for more is subject to appropriation by the New Hampshire legislature. So the New Hampshire legislature controls how many magistrates does the New Hampshire judicial system get after 3. These magistrates, they serve at locations as the Chief Justice of the New Hampshire Supreme Court ultimately determines. And magistrates are judicial branch employees. So they're not necessarily, and they're not judges, okay, in a constitutional sense. They do have some similar authority in a very limited sense. And we'll get into that, but that authority is strictly limited by statute and oversight by the Chief Justice and the administrative judge of the circuit court. Okay. So these are the following powers that New Hampshire law gives these magistrates. You can find this under RSA 491-B:2. First power, to determine the release or detention of defendants on all days of the week and at all times of the day. Okay, so that touches on bail. To conduct arraignment hearings and issue decisions on arraignments. Arraignments are your first appearance in court. That's where you're formally informed by the court what you're charged with, and they'll take your plea, and issues of bail can be addressed at an arraignment. It's frequent that arraignments and a bail hearing will occur simultaneously if what an individual got arrested for requires them to show up to court before they're issued bail. Okay, so the magistrate also has the authority to issue arrest warrants, issue search warrants, to administer oaths and affirmations, and to perform basically anything authorized by the Chief Justice of the New Hampshire Supreme Court that doesn't conflict with the New Hampshire Constitution or any other state statutes or federal laws. So think of that as a catch-all. Magistrates can only perform most of these powers if they're licensed to practice law in the state of New Hampshire. So in most cases, by far, your magistrate is going to be a licensed New Hampshire attorney. There's also some basic requirements. A magistrate must have at least 3 years of some sort of relevant experience. Okay. When a magistrate gets appointed, it's a term. So it's not an indefinite thing. And that term is set for 5 years. So when that 5 years is up, the Chief Justice of the New Hampshire Supreme Court doesn't have to renew that term. So think of that as a way of a potential way of dismissing a magistrate would be to not renew their term. So in practice, if a magistrate sets bail, for example, releasing a person accused of a serious offense, it's also subject to review by an actual judge. So, and we'll talk about that a little bit later on in the podcast. Now, we know what magistrates are, that they can preside over bail hearings. So next thing we need to do is we need to dive into what the bail statute actually says. Okay? So the first provision of the New Hampshire bail statute is RSA 597:1. And what it says is all persons arrested for an offense shall be eligible to be released pending judicial proceedings upon compliance with the provisions of the rest of the chapter. That means the rest of the subsections of this law. Okay? So right from the get-go, all persons arrested in a very general sense should be released. Not just should, they shall be released, which means or a magistrate doesn't have discretion to not release them pending judicial proceedings. So what that means is they've been arrested for something, but they haven't been proven guilty beyond a reasonable doubt. So they're presumed innocent until and if they're proven guilty. So this is just while the case is pending. They've just been arrested. Should they be released until the case is resolved? So I think bail is not meant as punishment because the individual has not been convicted. It just sets the conditions to, one, assure their safety, the safety of other individuals, and the safety of the general public, and two, to assure that they will actually show up to court. That's it. However, the rest of the chapter, that's the rest of the bail statute, does delve into it a little bit more about how those two things can result in someone having highly restricted bail conditions or not be released on bail. And we'll get into that right now. So, when considering whether to release or detain a person, the magistrate needs to consider the following issues. Like we discussed, the safety of the public, that includes can be a specific individual, and the defendant, him or herself. So, anyone charged with homicide, first-degree assault, second-degree assault, felony domestic violence, aggravated felonious sexual assault, kidnapping, felony-level stalking, or trafficking in persons, robbery, possession, manufacture, or distribution of child sexual abuse images, computer pornography, and child exploitation. Anyone charged with any of these offenses is not to be brought before a bail commissioner. So, in a general sense, for other charges, someone's arrested, they don't usually go in front of a a judge for a hearing right after they get arrested. So normally within 24 hours, someone usually goes to the arraignment. That's the first appearance in front of the judge if you're arrested for one of those charges we just went over. For everything else, a bail commissioner. So this is somebody that's authorized to set your bail conditions, and it's somebody you pay $60 to. They'll usually come to the police station if you get arrested, and they'll set your bail conditions, and you'll be on your way straight from the police station, or straight from a county jail if you're transported there way before you ever have a court hearing. But for these types of charges, which was, our case here for Michael Gleason Jr., they have to go in front of a judge. So upon arrest, he was presumably detained pending his arraignment before the court. So he was held until he got in front of the court. His arraignment, when he went in front of the court, was not in front of a judge, however, it was in front of a magistrate. Okay, and the magistrate has that statutory authority to conduct such hearings. Okay, that happened no later than 24 hours after his arrest. Okay, at the person's appearance before the court can either, and that's the magistrate, can either order that the person be detained pending trial, or released with those certain restrictive conditions. Okay, in order to be detained pending trial, the magistrate needs to determine, and that's based off of what occurs at that hearing. So what does the state say, and what does the defendant say in regard to the issue of bail? So based off of all that information, the magistrate has to make a determination. If the magistrate finds that there's clear and convincing evidence, and that's a high bar. That's higher than what's called preponderance of the evidence. So think of clear and convincing evidence as between beyond a reasonable doubt, which is the highest bar, that's to convict someone of a crime, but higher than preponderance of the evidence, which think of that as more likely than not. So it's higher than more likely than not. So clear and convincing evidence is a pretty high bar. Okay, and usually the prosecution, that's the state, needs to present some sort of evidence at that hearing to meet that standard. And if they don't, the magistrate has to release that individual. They can't hold them pending trial. Okay, they can't be held without bail based off of a gut feeling or things that aren't addressed at that hearing. Okay, so that clear and convincing evidence needs to be that that person is a danger to somebody, the public, or themselves. Okay, so when they're determining whether release will endanger the safety of that person or the public, the court can consider just about anything that's relevant and material that's addressed at that hearing. But remember, it has to be addressed at that hearing. So just be aware of that. Okay, and usually after that initial bail hearing, there can be a subsequent bail hearing, and that's more formal. So think of the first one as more ad hoc on the fly, because everybody, the defense attorney especially, but even the state might not have all the information. They might have additional information later on, because this is a case that, remember, this is something that just started within the past 24 hours when you're having this first bail hearing in front of the magistrate. However, at the subsequent hearing, if the court finds probable cause exists that the defendant violated the conditions of his or her bail, the defendant shall be held pending trial. So just be aware of that. If a person is charged with any criminal offenses and the magistrate determines by clear and convincing evidence, aside from just ordering preventative detention without bail, the magistrate also has the authority to still let them out on bail. That's the way the statute's written. It doesn't say that they have to get rid of their bail. And this is a very important thing where the wording plays a very, very, it's sort of contradictory in the statute, because it's first it says shall, which means there's no option, but under the subsection says if a person's charged, a magistrate determines by clear and convincing evidence, the magistrate may order preventative detention without bail. They can also order the defendant to comply with restrictive conditions to see if that can address any concerns. Can also order electronic monitoring and supervision, and that's usually supervision by the county, or it can be some sort of combination. It could be restrictions and electronic monitoring, so it's extremely common. Now, what type of evidence is addressed at a bail hearing? So it can be made by what's called offer of proof at the initial appearance, so at that first hearing before the magistrate. So that means the prosecutor, to meet that burden, and defense, the defense, either through the defendant, him or herself, or the defense attorney, can proceed by these offers of proof, which means the prosecutor just says what they would introduce, and defense says what they would introduce, okay, without actually introducing it. So think of that as a more loosey-goosey way of introducing evidence. And that's because of the immediate nature of it. It's not expected that everyone will have these witnesses actually at that first hearing within 24 hours have anything they want to introduce. So things are done by offer of proof. But these offers of proof, they must be actually true. They can't be made up stories. So officers of the court, the prosecutor cannot make up a story that they know is not true. Okay, that's a very quick way to get disbarred. Same thing applies for the defense attorney. There has to be a basis that it's true. However, at any subsequent hearing, now you can have live testimony from witnesses. It can be presented via video conferencing. Sometimes the court can determine, and usually defendant will assert, that the witness testimony actually be made in the courtroom. And this can be, it's not uncommon for defense to make this motion to request an evidentiary hearing where witnesses are actually present, because that makes it harder for the state. There is also a rebuttable presumption that the alleged victim of the crime is not required to testify at a bail hearing. However, an alleged victim can testify at such a hearing if they wanted to. Now, based on the information I have, I don't know if the alleged victim in this case actually testified at this initial bail hearing. They probably wouldn't. I mean, because of the ad hoc, it's quick. It's within 24 hours. They could be there for that initial hearing. They could also be there for the later hearing. But, with charges such as these, it's not uncommon for a victim not to testify. Now, this bail statute is being changed. So the law's already been changed. The new law is not effective until September 21st, 2025. Okay, now let's discuss how that law has changed. These are major changes. Okay, so the major changes in this law is if there's probable cause. Now the standard is lowered to probable cause instead of clear and convincing evidence. So the new statute says if there's probable cause that while on release for any previous offense or the current case, the person failed to appear, committed a felony, Class A misdemeanor, DUI, violating bail, there's a rebuttable presumption that the person will not follow their bail conditions, and that person shall be detained. Okay, now probable cause is more likely than not. Okay, think of that as 51%. It's a much easier hurdle to get over, okay, to have that person detained. However, this is a rebuttable presumption after probable cause has been found, okay? At the bail hearing, the defendant can present evidence to the court to try to overcome that presumption, to see whether such person has rebutted the presumption that release will not reasonably assure their appearance or comply with any sort of bail conditions, all right? Now, those major charges we went over before, those people, they're still not brought before a bail commissioner. So that stays the same, okay? However, if the person does have an arraignment, that standard for what they're arrested for is much lower now. It's not clear and convincing evidence. It's probable cause. So at the person's appearance before the court will order that the person be detained pending trial if the court finds by that new lower standard of probable cause that the release of the person is a danger to that person or the public. Okay, and they use the same evidentiary standards that we went over before. So now the bar is much lower. It's more likely than not. Okay, more likely than not. It's a very easy hurdle to overcome compared to what it currently stands before September 21, 2025, which is clear and convincing. That's very high. Clear and convincing means the evidence needs to be very clear and very convincing to the judge that there's a threat. Okay. In this case, we don't know what happened at that bail hearing. That was, the first bail hearing, that was an arraignment. That's the arraignment where the prosecutor may not have enough time to really present a strong case for pretrial detention. Okay, and that's something we all have to keep in mind. All right, there needs to be clear and convincing evidence. It doesn't appear that this person involved in this case had a subsequent, more in-depth bail hearing. Okay, and remember, the person is to be released unless the state can convince the judge or, somehow by clear and convincing evidence that the person is a threat to themselves or the general public. If a person under the new statute, so what this individual in this case was charged with, if they had violated the conditions of their bail, they would be held. And if they found probable cause that the person violated the conditions at their bail hearing, they would be held pending trial the whole time. So they're initially held if they get arrested while they're out on bail until they get in front of the judge. At that hearing, if that judge finds probable cause they violated their bail for those serious crimes that we went over, the defendant's held. Period. That's it. Now let's talk about the magistrate's decision. Okay. How's the magistrate's decision reviewed? Okay. So the case, all criminal cases are eventually going to be scheduled for some sort of hearing down the road. Some sort of hearing where a magistrate's not going to be presiding over, it's going to be an actual judge. And that's because of the very limited authority of magistrates that we went over in the statute. Now, these judges, when there's a later hearing, these judges, once it gets, to them, they can amend the bail order on their own. That's called sua sponte. It means do it on their own. Okay. So the magistrate might have certain bail conditions. The judge might view it differently, and they might revoke their bail. They might add more restrictions. Okay. So that's a way that the magistrate's decision, one of the ways, there's many ways. That's one of the easier ways that the decision can be reviewed, because eventually an actual judge is going to get their eyes on it. And it looks like in this case, 2 judges got their eyes on it, and they did not amend the bail order on their own sua sponte. So something to bear in mind, whether they should have or not, we're not getting into that in this podcast, okay? We're just going over what the options were to review the magistrate's decision, okay? Additionally, the defendant or the state can file with the superior court. So think of that as the higher court, because the criminal case is starting off in district court. So this also could have done something, and it doesn't appear that they did. They may or may not have, but it doesn't appear so. They could have filed with the superior court. They could have filed what's called a motion for revocation of the order. So whatever that bail order was, they could have said, sorry, magistrate, we don't agree with you. There's an imminent threat to the alleged victim's safety. They could have filed a motion to revoke that bail order to a superior court judge who would have reviewed it and made an order. Okay. So just be aware of that. Okay. This option is also available if it wasn't a magistrate, if it was a judge that had issued the order. So, hypothetically, as the case had proceeded, the judges could have made a bail order sua sponte. They could have changed the bail order. They could have revoked the bail order. The state could have asked a judge, once it got to a judge, down in the district court, to revoke or amend the bail order to make it more restrictive. So there's lots of ways that things could have been changed, and it doesn't appear that they were. So just be aware of that. The state could have made a renewed motion. They could have, way back when that initial order was given by the magistrate, the state could have filed what's called a motion to reconsider to that magistrate, which is kind of a last-ditch attempt to change the magistrate's mind. I'm not aware of whether that was done or not. So these are all things that whether they could have, should have, whether they actually happened is undetermined. But in my experience, it's highly uncommon for a motion to reconsider to be filed by the state, even though they can do that. They could also ask that actual judge, review that bail order subsequent to the motion to reconsider if it was denied by the magistrate. So these are just things to keep in mind about how the system is set up. Additionally, all magistrates have administrative review, okay? So they have performance reviews to assess, are they applying the law properly? You can make complaints. There can be discipline, reassignment, even removal, okay? There can be reviews. They can be informal or formal, okay? So these are things to bear in mind. In reality, this would be dealt with in most instances by far by the administrative judge of the circuit court. So think of that as that would be the boss of the magistrate. Okay, so that person is the boss of all the district court judges and the magistrates under them. Okay, so they can issue guidance, they can do corrective action, they can recommend discipline, and to the extreme instances, removal. If it's warranted, they can remove them. So just be Just be aware that that's one way. Another way is what's called the Judicial Conduct Committee. This is an independent body responsible for investigating judicial misconduct in New Hampshire. These committees, they consist of judges, lawyers, just regular members of the public. They operate independently of the courts and the legislature. However, when it comes to the Judicial Conduct Committee, only the New Hampshire Supreme Court can suspend, censor, or remove a judicial officer. Okay? But the Judicial Conduct Committee does the investigation, and they can make recommendations to the New Hampshire Supreme Court, but the New Hampshire Supreme Court, the Chief Justice, has the ultimate authority when it comes to judges to suspend, censure, or remove them. Okay? Again, who can remove a magistrate? The administrative judge of the circuit court. Okay? They can reassign them. They can limit their authority. Maybe their authority could be limited to, you don't do bail hearings anymore. Maybe you don't do them until you're retrained. Maybe you're suspended entirely until you do some retraining, or maybe you're suspended until we conduct an investigation. These are all things that could be happening. Okay. It looks like there is some sort of internal investigation, but it hasn't been determined who's doing that. What type of investigation? Is it the administrative judge of the circuit court doing the investigation? Is it a judge, a lower judge investigating a magistrate under them? We don't know. We don't know what that looks like right now. Another action the administrative judge of the circuit court could take is once that magistrate's 5-year term is up, they could just not recommend that they be reinstated for another 5 years to the Chief Justice of the New Hampshire Supreme Court. And that, in effect, gets rid of that magistrate. Now, in very extreme circumstances, New Hampshire is a small state. We have a lot of legislatures per person, and they pay attention to what's going on here. Okay, so the New Hampshire legislature has the power of impeachment. That power of impeachment is a way to get rid of somebody. So it requires 2/3 of the House and 2/3 of the Senate to impeach someone. So once we get 2/3 of the New Hampshire House, it would get transferred over to the New Hampshire Senate. And in the New Hampshire Senate, they would actually have a trial in the Senate. And then at the end of that trial, the jury basically would be the senators themselves. Okay. And they would need 2/3 of the senators to get rid of that judicial officer. Okay. The power of impeachment does not extend to magistrates, such as the magistrate in the specific case we're going over. And that's because the magistrate is not a constitutional judicial officer. They're employees of the court. They're not judges. Right? They have limited authority. This authority is given to them by 1, statute, and 2, by actual judges, such as the Chief Justice of the New Hampshire Supreme Court. So they are just employees at the end of the day. So they cannot be impeached. And impeachment is very extreme. In a circumstance where you need 2/3 of each house, would probably be easier to just change the bail statute rather than impeaching a magistrate. Hypothetically, if they could impeach a magistrate, which they can't right now. Okay. So these are things to be aware of. So, New Hampshire, citizens in the state need to think about, if things go wrong as well, when someone's out on bail, is a judge or magistrate really responsible for that? These are things people should think about. I'll give you an example. It's just not strictly on statute, but just common sense. Let's say someone gets arrested for smacking someone in the face. Let's say they get bail. Their bail's $1,000 for smacking someone in the face. Okay. They get released on bail by the magistrate. Let's say 5 days later, that person shoots up a shopping mall. Okay. Does it make sense that magistrate should be asked to resign, or they should be disciplined in some way, or that they applied the law improperly, that they did their job improperly? Of course, no, because nobody has a time machine. Okay. It's easy after something happens to say, play Monday night quarterback that, they could have done this, they could have done that. They're applying the law and the evidence at that bail hearing, period. Okay. And they're assessing the likelihood of someone being a threat to someone's physical safety in a very extreme sense. Nobody can really determine that. Okay. In this instance, with the facts given here, should bail have been higher? Or should it have been denied? Well, that depends on if the state met its burden. Remember, it's not the judge's burden. It's not the magistrate's burden, okay? It's the burden of the state to put on evidence to convince the magistrate that there's clear and convincing evidence of why that person should be denied bail. So it is a little odd to me that most of the focus has been on the magistrate and not just the prosecution. So everything should be looked at. Okay. All concerned citizens should think about every player in the process, not just the easy target. Okay. It's understandable when a tragedy like this happens. People want to blame someone because that's easy and convenient. That doesn't mean they did anything wrong. Did this magistrate in this instance, could they have done something wrong? Maybe. Is it to the level of they need to resign? We don't know. That's the whole point of conducting a review. Is it something that can be addressed with retraining? Perhaps. Should they be suspended until that retraining occurs? Maybe. Should they not be reinstated? Perhaps, or maybe they just shouldn't do bail hearings. There's a lot of things to look at. Or maybe they did everything they were supposed to do and the state did not meet its burden. Okay, maybe they followed the law. Maybe the issue was the current statute, which is set to change September 21st, 2025. Tragedies happen. Do we wish we had a time machine and we could go back in time? I'm sure that anybody in the magistrate's position, if they had that information, would have denied this individual's bail. But they didn't have that information. They only have what they get 24 hours after the arrest at that hearing. Okay. So these are things to think about if people want to get involved in changing the bail statute. Maybe it should be preponderance of the evidence at the first hearing because of the risk. Okay. Maybe there should be the later hearing. Maybe the standard shouldn't be preponderant. Maybe it should be clear and convincing evidence. Okay. Who knows? These are all things that every person living in the state has to think about and has to communicate with their legislature and see what changes need to be made to the bail statute. It's a process. But before people start demonizing, people need to understand what they're talking about and whether someone did something wrong. And most importantly, I see a lot of comments on news articles as if, oh, well, this person was arrested for so-and-so and this and this. Remember, they're innocent until proven guilty for what they're arrested for. That doesn't, bail is not a punishment. Your bail conditions are not them being convicted of the crime. Okay, someone can be arrested for a horrendous crime and be innocent. Okay, merely being arrested for atrocious crimes does not, in and of itself, warrant having your bail revoked. That would be, it would lack due process, and it doesn't make logical sense. Right? Someone could just be at the wrong place at the wrong time. There needs to be some sort of evidence and due process that shows, hey, this person is a threat to themselves or others. And that's why they should have highly restricted bail conditions or bail should be denied entirely. And we can't just say, oh, well, this person's been arrested for an egregious felony and just say, oh, well, that's what we arrested them for, but we're not going to put on any evidence in front of the judge and then say, well, the judge or the magistrate screwed up because they let the person out on bail. Okay, remember, there's a legal standard. Okay, the defendant has rights, everybody has rights, but you can't strip away those rights when tragedies happen as well. People have to be careful about when things like this happen. The law can be, rather than applied more properly, it can be applied improperly. Okay, if people are too afraid, if a magistrate or a judge is too afraid to set bail when they should release someone on bail because of what's happening in the news, that's not good for anybody. Okay, because that can result in someone who may be innocent or even someone who may be guilty but they should be released until they're convicted. And then when they're convicted, they'll be punished for what they did. But, somebody that should be released, they might be held in pretrial incarceration when they shouldn't, because maybe a magistrate is too afraid to let them go because of all the public outrage. Okay. People need to be responsible citizens of their state. We can't have mob rule, especially where mob rule is mostly based on what did the news article say, but the news article is frequently missing critical information. Person reading it, your lay person, isn't an attorney. They don't know the rules. And I frequently see they don't even understand what the purpose of bail is. They view bail as a punishment. Or they say, oh, well, this person was charged with this. Why were they released on bail? Remember, there needs to be some sort of evidence. You can't just say, oh, well, I'm charging you with this so you don't get bail. Okay, that doesn't make a lot of sense. The state can charge anybody with anything, and it could be you one day. So if there's an injustice against one or a few people, it's really an injustice against our entire society. Okay, so it's something we need to keep tabs on. People need to get involved in, and it looks like that's happening, but people need to know what they're discussing. It's very easy and convenient, to have a scapegoat and say, oh, well, this horrible tragedy occurred. Who gave this person bail? Oh, it was a magistrate so and so. Magistrate so and so is a bad person. I mean, that's just a cheap shot. It's a cheap way to look for a scapegoat to appease a mob. It's not proper. It's not how the law should be applied. Everything needs to be looked in depth. Reviews need to be undertaken. Training needs to be reviewed. These are, more people need to get involved. There seems to be a lack of involvement, perhaps. Judges, maybe they should be more proactive. Sua sponte, are they reviewing these bail orders made by magistrates in every case? I don't know. Nobody knows. Okay, so it's something to be aware of. All right, are prosecutors really are they appealing these bail decisions? Are they asking for reconsiderations? Are they asking for additional bail hearings? Are they asking for a different judge to review the bail orders? I don't think that's happening. I don't see that happening a lot. It seems a one-off and then that's it. So something to keep tabs on. Usually these follow-up bail hearings or appeals, it's usually the defendant, the defendant's attorney trying to get their client out of jail. I'm not seeing a lot of prosecutors, appeal a bail order, ask for a bail order to be reconsidered, ask for a bail order to be reviewed by a judge. I'm not seeing a lot of that. But also be aware, prosecutors are a big part of this. They have to prove their burden. Okay, they are the state. The state has the burden right now of clear and convincing evidence. They have to meet that burden. If they don't meet that burden, the magistrate or judge is supposed to release the defendant. That's what the law says. They're supposed to release them, period. And you can't go blaming a magistrate for following the law. I mean, what do you expect? Bail is not just based on a gut feeling. It's not, oh, well, what would the mob like me to do? That's not how the law operates. It's not politics, okay? Obviously, there's some form of politics, but we have to be careful. We don't want politics and what the mob wants to be creeping into the justice system. It's a danger. It's a threat. The bail is being reformed. It was changed. Now it's being changed again. We can't go too far to the other side where we're holding people in pretrial incarceration that may be innocent, or maybe it's not worth it to society to hold them in maybe it does damage. Because remember, when someone's in pretrial incarceration, they're not working, they're not paying taxes, they could lose their home, their families could be impacted, other people could be impacted if they lose their jobs. So it's not necessarily a great thing to hold someone in pretrial incarceration just because it sounds great. People that pay property taxes in New Hampshire, people need to also remember, you can't just throw everyone in jail. Jails have limited capacity, okay? It also costs, it probably costs like, who knows, $30,000 to $40,000 to hold someone in a jail. Is that what we want to be spending our money on for someone who's not dangerous? So these are all things we have to keep aware of. There's a consequence to everything that we do, okay? And if there's more reviews and more work, that also is going to probably cost some sort of money in the judicial system. But is it money that should be spent? I would say absolutely, because this was a tragedy. Should Michael Gleason Jr. have been released? That's something that we all need to look into. We all need to review. We all need to review the facts of how this tragedy happened. Okay. And if, Marisol Fuentes' death could have been prevented somehow, we need to take this as a learning opportunity to prevent future homicides from occurring due to instances like this. So we need to keep tabs on it. We need to do reviews, and people involved in the judicial process, they need to be more proactive. But the public needs to be more responsible. The public cannot go scapegoating based on a lack of information and convenience. And the public needs to be careful because politicians, and we're already seeing it, politicians will jump on stuff like this and they'll use it to make themselves look good. So just be aware of that. They could use it to make themselves look good. They could use it for their own gain, which might not necessarily be what people think and what they want. So just be aware of that. People out there are opportunists. So remember that from the information you're getting. There's always an angle. There's an angle from a media source. There's things missing from a media source. And also be aware of there's things you know and things you don't know. Okay. So think about that before forming an opinion and putting pressure on politicians or other, individuals or institutions of power. Because, the public has the ultimate power, but the public needs to be aware of how that's used. You don't want to put pressure the wrong way. Okay. For example, You don't want people not wanting to be magistrates because they're worried about things like this happening or the public outcry happening. So, people need to be aware of that. So, I'll say again, I hope this has opened everyone's eyes to bail and the role magistrates play. But it's not just the magistrates, okay? There's the prosecution. The state plays a major role. The administrative office of the courts plays a major role in reviewing judges and magistrates' conduct and whether there should be adequate training, retraining, suspension. These are all things that need to be looked at in depth. So thanks for joining me for the first episode of Granite State Crimes here on Law Talk NH Unfiltered. I hope you found this deep dive into the New Hampshire's legal system insightful. I continue to offer my sincere condolences to those affected by the tragic events that we discussed today. If you want to stay updated on future episodes, please subscribe and share this series with anyone interested in the law and justice in our state. This podcast is brought to you by Stone Law, PLLC, where I'm dedicated to serving the community with honest and experienced legal representation. If you or someone you know is facing legal trouble, please don't hesitate to contact me for a free consultation. My contact information is available in the episode description. If anyone has any questions or case ideas for future episodes, feel free to reach out to me on social media. Until next time, stay informed and take care.